We don't have time to act legislatively. There's no question about that. Our legislative runway's over. The House will rise at some point, perhaps as early as next week. And so, but that being the case, it is normal to have, the normal response period for a report is 120 days. So that's 4 months. I hope to be coming back in this role. I hope that our government will get reelected, and so we'll be able to hit the ground running. I think the main suggestion in the room is we need to look at the criminal law, and so I'm still going to stay general, if you don't mind, in the answer, but really look at what is within our jurisdiction, i.e. the criminal law power, and trying to really achieve that balance, as a number of people in the room have stated, of trying to draft a criminal law provision which targets only intent and not criminalize everything else, which we have seen the negative impact of over the course of the past number of decades.
One thing that I think it would be quite reasonable to expect would be in the report is a recommendation that to the extent that there is any application of the criminal law to deal with allegations of HIV non-disclosure, it is not something that should be dealt with as a matter of sexual assault. I think there was a very strong view expressed by virtually all, if not all, but almost all witnesses before the committee, that sexual assault laws are just misapplied in this context. And that's been something that HIV advocates, including the Canadian HIV/AIDS Legal Network, have been saying for many years. So I am hopeful that the committee heard that message and will include that as a really important recommendation. I think it's also important to note that most of the witnesses who appeared before the committee also pointed to the fact that we should be limiting any application of the criminal law to cases of intentional and actual transmission of HIV.